Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Crossing.
How likely is a divorce judge to report tax fraud it discovers in open court to the taxing authorities? If either during the course of discovery or at trial, a family judge happens to learn that a witness or a party has committed tax fraud, does the judge have a duty to report the discovery of the tax fraud to the taxing authorities? My research shows that the judicial decision whether or not to report tax fraud that a divorce court discovers to the taxing authorities is a complicated issue. These divorce judges are faced with a multitude of overlapping federal, state, and ethical rules and rulings to contend with. Most judges, faced with the decision whether or not to report tax fraud to the taxing authorities, will exercise judicial restraint and invest serious contemplation time in considering the issues before reaching any decision. A divorce court will often exercise a different level of scrutiny over attorneys before them, as they are officers of the court, than it will to the general public who comes before them having committed an apparent or alleged tax crime, but yet are seeking the benefit of the legal process to obtain the shelter of the law in their divorce. The judge is placed in a quandary. First of all, a courtroom is not a duty-free zone where a crime can be admitted to with impunity. A blanket judicial attitude of hear no evil, see no evil, report no evil would not inspire public confidence in the judicial system. In exercising its judicial discretion, the court's going to consider the nature and the seriousness of the offense admitted before it. The court's going to consider whether the crime has a victim. This is especially important where the victim is the other spouse before the court. The court is also going to consider whether the victim, the spouse, is operating under a disability that would interfere with the victim's ability to report the crime. The court's going to consider the conclusiveness of the information or evidence before it that a crime has actually been committed. It will consider the recent, remote, or ongoing nature of the crime. The court will consider whether there's a danger to the community that exists or whether the public trust is involved. A divorce court faced with an admission of tax fraud is going to realize that one spouse cheating on their taxes and then lying about its income and assets in disclosures to the court is going to negatively affect their spouse's confidence in the judicial system if they allow it to occur. The court is also going to consider the husband and wife's children and their needs in dealing with this issue. When a party to a divorce commits tax fraud and then follows that up by understating their earnings capacity to the divorce court in an effort to undercut their responsibility to support their children, this would cut vitally against public policy and would appear to tilt the scale in favor of disclosing the tax fraud to the taxing authorities by the divorce court judge that learns of it. Here's the scary thought. Under the best interests of the child standard, a divorce court could face this situation. The divorce court can learn that both husband and wife committed tax fraud. Any civil liability would be a marital debt subject to allocation between husband and wife and distribution as part of the marital balance sheet. That's simple enough. If a couple comes before a family law judge and the court learns that both husband and wife have perpetuated tax fraud together, the civil liability and criminal exposure to both husband and wife become at issue to the divorce court because of the best interests of the child standard. If fraud is ultimately proven and tax charges are assessed against the couple, if one or both of them are incarcerated, this would certainly impair the couple's ability to support the children. Therefore, a referral from the taxing authorities by a family law judge who becomes aware of the tax fraud could be against the best interests of the children. In my research, the strongest reason for a divorce court judge to make the referral is because under 18 U.S. Code Section 4, there is a misprision of felony statute that applies to judges. 18 U.S. Code Section 4 in this prison of felony statute reads as follows. Whoever, having knowledge of the actual commission of a felony that is cognizable by a court of the United States, conceals and does not as soon as possible make known the same to some judge or other person in civil or military authority under the United States, shall be fined under this title or imprisoned not more than 3 years or both. The mere existence of a federal imprisonment of felony statute dictates a logical conclusion that federal public policy potentially requires a state family law judge who learns that tax fraud has been committed in a divorce proceeding before them, that they're under an ethical duty to notify the federal and state taxing authorities of the crime, even considering the fact that the judge could potentially only be prosecuted under this statute through some affirmative act of concealment.